would like to address the first question. To the best of our knowledge and record available to us, the developer of the site has nothing to do with the administration, because all that we have, the only record we have in our disposal is Santos Estate Limited. Thus, to the administration, we are dealing with Santos, not with the former chief of naval staff. So if Santos on his own had gone ahead to pass through the land and then start disposing to individuals, is another breach of terms and conditions of the letter of intent issued to him in 2007. But as clearly stated, letter of intent was issued to Santos for development and maintenance of park and not residential or other purposes. So that is that. To the best of my knowledge also, we have not received any communication from the military as regards to the unfortunate incident that happened. But we are also very happy if investigation can be conducted to find out the remote causes of all these unfortunate incidents that occurred on Tuesday.
Yeah, to add to, because the question he asked whether communications have been sent to both departments, an important question. That's exactly what the FCT administration has begun since June 2025. I did say earlier that following the identification of the various lapses, especially in the area of superintendence of places seen as parks, the administration looked thoroughly into all the issues and made a submission that will streamline the activities. And it was necessary to withdraw all of those papers, having not been titled in the first place and having not been properly documented in accordance with the proper guidelines for doing so. Some of the places allocated as parks by the Department of Parks and Recreation are not places that would have been so. Park is park. It's not everywhere that is park. Green area doesn't mean park. Buffer zone doesn't mean park. Transportation corridor doesn't mean park. Park is a designated land use recognized as a land use in its own merit and is designed and configured to be so. So it is all those parks, proper parks, that will be titled for park purposes, mostly in favor of the Department of Parks and Recreation, who will now sublease them. By parks policy of the FCT administration of, I think, 2005 or 4, and the reviewed one of 2019, all parks are to be titled in favor of the Department of Parks and Recreation, Federal Capital Territory Administration. Titled means they will be granted statutory right of occupancy and certificate of occupancy. Those documents will be domiciled in the land registry of the Department of Land Administration, the originals of them, and then photocopies made available to the Department of Parks and Recreation, with which they can now grant subleases. But in this case, most of the places are not parks at all. They are either road corridors, buffer zones, green areas, and all other incidental open spaces. And the department will go on and grant letters of intent. Now, in streamlining the activities, they all had to be withdrawn. And then those holders of those papers were asked to submit them for vetting. So many have complied, and we are dealing with them. But definitely, not all of them will get those spots back. If, for example, they have given you paper over a road, an expressway, even a minor road, whatever it is, or some other places that should be of a public interest, we are not going to give you any paper, whether statutory right of occupancy or any temporary permit on such a place. Because we would have committed ourselves to granting statutory right of occupancies on roads. When the roads are about to be built, you now start talking about revocation and demolition and all of the complications. Those people will not get those spots back. They might be considered for alternative sites. Then the ones that are parks as designed and designated as such, will be granted to the Department of Parks and Recreation, or if the administration so desires, depending on our assessment of the applicant, they could be given directly to the applicant for longer term of longer lease term, maybe 99 years.
So in addition to that, I know the Department of Land Administration, ages, and even the important question. But before I answer this question, once again, I want to sincerely apologize to Nigerians for that regrettable action. As said, it's not in my character for such an emotional outburst. But seeing the effort made to resolve this matter amicably, and the way and manner the officers responded, I felt betrayed. Because I have done it in the open, not once, not twice. I did it secretly by sending message to the officer concerned so that we could have a robust discussion with the CNS how this thing could be avoided. But unfortunately, we couldn't succeed. As I said, as a human being, sometimes we are fallible. I deeply regret that action, and I'm deeply sorry. Thank you.
ESCO, I have not received any communication from either Santos or the former chief of naval staff regarding the subject matter. There is no communication of any sort in that regard. In support of the submission of the Director of Development Control regarding the incident of Tuesday, the 11th of November 2025, I would like to make the following clarifications. The issue here is about whether somebody has title to land and whether he has the requisite approval to build on the land. And the answer to the two of them is no. He doesn't have any of those. The claimants have relied on a letter of intent issued by the Department of Parks and Recreation in 2007, 18 years ago, to develop, manage, and operate a designated park site. Letter of intent, not statutory right of occupancy. I wish to make it clear that in the FCT, the only thing that gives you title to land is statutory right of occupancy. Letter of intent is not a title. It's a mere permission to enter upon the land and do specific things. In this case, to manage and operate a designated park site. The letter issued to Santos Estate Limited is dated 5th July 2007. And it says, following your expression of interest to develop, manage, and operate a designated park and green in the FCT, and your subsequent qualification to do same, I wish to convey the approval of the FCT administration for the leasing of park number that and all of that. But very importantly, on the following conditions. First one is that this letter of intent is to enable you commence negotiation with your financiers and immediate site preparation. The second condition is that you submit a detailed technical design proposal for approval within 21 days from this date, 21 days from the 5th of July 2007. That the lease agreement shall be given to you upon approval of your detailed technical design proposal and payment of all necessary fees. That the park be developed and completed according to the approved technical proposal within 1 year from the date of approval. On completion of development of the park or green area, the general public shall have unhindered access to its usage. Any contravention of the above stated conditions can result in the revocation of the allocation. Thank you for the interest in the development of the Federal Capital Territory Administration. These were the conditions handed down to Santos Estate Limited in 2007. He did not submit detailed technical design proposal within 21 days. In fact, the first of such submission came in 2023, 16 years later. He did not meet, since having not submitted detailed technical proposal, no lease agreement was given to him. He did not develop and complete development on the site within 1 year, as he didn't build anything by 2008. And we made it clear that if he contravenes any of these conditions, this thing will be withdrawn. There are so many of such cases. And this administration, in its quest to handle land administration activities much more professionally, embarked on serious reforms. So many departments and agencies that were purporting to handle land matters were looked into, the activities were looked into, and the operational framework developed. In the case of the activities of the Department of Parks and Recreation, the activities were reviewed, every of the things they did, and the performances relating to all of the papers they issued were reviewed, discussed, and a submission jointly made by the Department of Land Administration and the Department of Parks and Recreation on the 10th of June, 2025. And one of the recommendations there in that joint submission was that all letters of intent and every approval of any sort on the basis of the letters of intent given by Department of Parks and Recreation be withdrawn. All. And people who were given these papers should send in their papers for vetting so that the ones that are really parks would be looked into, and if they had ministerial approvals to have those papers, they will be considered for a proper allocation in line with the dictates of allocation of land in the FCT. That submission, a 15-page memorandum, was approved on the 19th of June by the Honorable Minister of FCT, withdrawing every form of letter of intent, any of such letters given by the Departments of Parks and Recreation, Abuja Metropolitan Management Agency at that time, and Abuja Metropolitan Management Council later on. Suddenly, so many people who had done nothing, who had not even attempted to submit any document to the Department of Development Control for approval, moved into all of those places to start developing. They were not even developing what they were asked to do by virtue of those papers. They were now going into other kinds of development. In the instant case, building housing estates, attempting to build hotels, and other forms of incompatible land uses associated with the park area in question. You couldn't have gone to do anything when you no longer had the permission to remain on the plot. It was withdrawn in June, and the said development commenced in September or October. You had no reason to enter there. Beyond not having title, in Abuja, you cannot build anything without approval of the plans you've submitted. Because the Department of Development Control will look at your design proposal and certify and ascertain that what you've proposed to develop is in line with the dictates of the master plan. Their submission, of course, in 2003 was turned down because he brought in things that were not allowed. That is beside the fact that it has taken about 16 years for something which he should have done in 1 year. He made an application to the then minister in 2015, asking that the place be converted to hotel, hospital, apartments, and housing estates. Approval was not given because that was not the intention of the area. Southern Parkway is a specialized concept in planning. From Mabushi, the interchange at Mabushi going towards Life Camp, what you see after the Ministry of Works and Housing, all those developments left and right of it are the kind of things we are talking about when you are talking of parkway design. From Central area, specifically from the Mabushi roundabout, through Life Camp, through Cafe and all that, you have that corridor. And that one is called Northern Parkway. The others, down the other way, through the Ahmed Tinubu Way, is the Southern Parkway. And that is the one that affects the area we are talking about. The Department of Urban and Regional Planning is the department charged with the responsibility to design and review master plan or anything about providing this and that anywhere in the Federal Capital Territory. And they came up with the design of the parkway, which had been reserved for proper detailing. They detailed the area, the Southern Parkway from Gadua end, which of course, left of it touches Gadua, right of it Dubois, and all that. It crisscrosses through several districts. And they did the design. It was approved by the minister, and it was sent to the Department of Land Administration for implementation. And that's what we've been doing. Santos Estate Limited is not one of the allottees that has been considered so far. He is not in anywhere in our records with respect to statutory grants or any right of occupancy in that regard around the area in question. We know all the allottees. They possess their statutory rights of occupancy, stating the land uses for which the lands have been granted. They have been given COFOs with which they could approach the Department of Development Control for development in line with the terms and conditions of grants. So it's really unfortunate that somebody will be claiming title when he doesn't. Letter of intent is not and has never been a title in FCT. It's a mere permission to enter upon somewhere and do something on a temporary basis. Some of the holders of letters of intent are holding, even for the parks, especially for the so-called parks, are holding these letters over major expressways that will come, that is yet to come. But because government is not ready to build all those roads and expressways and some other things, they are giving these places on a temporary basis so that that would not be a hideout and a heaven for criminals. That's why it remains temporary. Nobody gets statutory right of occupancy on them. Nobody is allowed to make any conversion because those things are temporary until government decides what to do with them. So the claims by the Santos about title is false. He doesn't have any title to the place. He was given a letter of intent and he didn't meet any of the conditions. He didn't submit building plan for approval within 21 days. He submitted after 16 years. And it was reviewed and turned down. By the way, he was asking to develop something incongruent with the land use. And an interdepartmental committee was set up, comprising of course, the Development Control Department, the Lands Department, the Abuja Geographic Information Systems, the Department of Urban and Regional Planning, the Department of Surveying and Mapping, the Department of Parks and Recreation, and the Department of Engineering Services. And they looked at the submission made by Santos Estates Limited and found out that it was not going to be approved. And they were so informed in writing. They were further advised to approach the Department of Urban and Regional Planning for anything they want to do that will review what the place has been granted to them. And there is no indication that they did so. There is no indication that the Department of Urban and Regional Planning considered their request favorably. All they did was, after all of those papers were withdrawn, they moved into those sites and started building illegally. Thank you very much.
With a sense of commitment, emotion, and regret, that we address this press conference on the incident that happened on Tuesday, 11th of November, 2025, at the Gadua district. We recall the unfortunate incident that happened, which was became a national issue in respect of a particular development taking place within the Gadua flank of the Southern Parkway. On the 17th of October, staff of Department of Development Control, on routine monitoring of ongoing developments within respective districts of the Federal Capital City, noticed an ongoing development within the corridor of the Southern Parkway. And on open inquiry, the necessary approval status and documents, they were met by stiff resistance and threat to shoot by men of the Nigerian Navy. The matter was reported to me on the 18th. I appealed to a colleague and coursemate in Kuru, who is a naval officer, to intervene and prevail on the officers on site to attend to our request. So the request was granted. We visited the site in the company of the Chief Security Officer to the Honorable Minister. While there, we met the officers on the site, and then I inquired necessary title documents and approvals granted for the development. The response we got was all their title documents, all their approvals are with their lawyers and engineers. We advised that for every site, every development, such documents are kept on the site. I insisted that, okay, give me the contact of the lawyers and the engineer. With several appeals, the engineer sent me what happens to be a letter of intent for the development and maintenance of park allocated to Santos Estate Limited in 2007. We came back on Monday, the same site. I met the officer, Navy Lieutenant Yerima, and I appealed to him, please, if you have this approval, show it to us, because what was sent to us is not an approval, it's just a letter of intent issued by the Department of Parks and Recreation. So while the discussion was going, the lawyer came. And the lawyer said, no, they made submission to Department of Development Control. I said, as a lawyer, there is a clear difference between submission and approval. And you know it is illegal within the provisions of the FCT Act of 1976 and the Urban and Regional Planning Law of 1992 to commence development in the Federal Capital Territory without approval. He said he's aware, but the submission is under process. I said, please, then this development is illegal. So when I noticed this, I withdrew my men, went back, but I tactically sent a message to Navy Lieutenant Yerima, intimating him that, obviously, his principal has been scammed. And I appeal to him, please let me get in touch with your principal so that I can advise him properly, because I have been informed that he's a man of honor and high integrity. Till today, Yerima has never even acknowledged my message. Then I went back with my management staff to see the status of ongoing development. That was on the 18th. Still, nothing but the refusal to stop. And I reported to the Honourable Minister that there is a site being developed by the former Chief of Naval Staff. We inquired about their development approvals and then their title document, which they have not shown us except a letter of intent issued by the Department of Parks and Recreation. So I go back and stop them. I told him that there was a threat that they are going to shoot at site because they are working under directive and order from their superior. I said, okay. So he gave further directive that do everything possible so that they comply with the provisions of development control guidelines. At this point, gentlemen of the press, I want to sincerely apologize to the Honourable Minister for dragging him into this situation on that fateful Tuesday. Why did I drag him into that situation? Because on the 17th of July, 2025, Department of Development Control lost a staff, Bilkisu Olusokomi Fasasi, as a result of demolition activity. In December 2024, 4 of our staff were beaten, manhandled in Lugbe because of demolition activity. Some of them got fractured. Up to now that we are talking, our heavy-duty equipment has been impounded at Ugosa by men of the uniform. So on that fateful Tuesday, when we are there to enforce the directive of the Honourable Minister, we notice the impending danger because armed men were strategically positioned, ready to shoot. And seeing this, I sent a district call to the Honourable Minister to come to the site for on-the-spot assessment. And on getting there, that ugly incident happened, which is, I'm really sorry for Honourable Minister. I apologize for Honourable Minister. Indeed, to all Nigerians for what happened. But one thing is clear. The development on ground is not in line, has not been approved because there is no title document. What is being issued to Santos Estates is just to develop and maintain a park. That is all. So I think nations rise and develop when we follow laws, obey orders, follow laws, as well as govern by rule of law. So it is unfortunate that we have issued order, nobody respected it. So I'm really sorry for what really happened. So this is, in a summary, this is what really transpired that Tuesday. So advise intending developers to always contact relevant departments and agencies on information regarding ownership, authenticity of documents, approval status, so that they will not fall prey an innocent victim of such circumstances. So there is that room of awareness, and your colleagues in the press, they have been so helpful. Anytime we meet, they try to create awareness as regards to land allocation, administration, and development in the Federal Capital Territory. Thank you.
Then further to your question regarding how to confirm authenticity of land documents. We don't have any problem with that. Any land allocated by the FCT administration, properly allocated, can be verified at the Department of Land Administration.